I'm going to make an announcement just so that we're all clear. There are some cases here that are, I'll just say, controversial in whatever nature, not really relevant to the court. I expect everybody to behave themselves as they should in a courtroom. My understanding, and it has been reported to me, that there were photographs that were taken in the courtroom. It is not permitted. I'm going to place you on notice that if that does occur, what will happen is your phone will be confiscated. You will be removed, potentially arrested. So please do not do that. I don't want to have to do any of that, but I will.
Right from the start, the judge is setting the tone. This isn't just courtroom etiquette, it's a legal warning. Taking photos inside many courtrooms can violate court rules and even lead to contempt or removal. Question for you. If someone ignored this warning, should they be removed immediately or should they get one second chance?
We'll expect order and decorum in this courtroom. So that we all have that understanding? Wonderful. Court does call the case, People versus Brandon Ham.
I'm Brown, Deputy Chief Public Defender, and read that on behalf. Did you have a chance?
Hello, Your Honor.
Hello.
We are asking for an adjournment, as you probably saw in your file. We have some discovery to receive in this case and go over with my client.
Your name, sir?
Brandon Hampton.
How much time are you going to need, counsel?
2 weeks, Your Honor.
Probable cause conference, November 21st, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Everything seems routine, an adjournment is granted, everyone's about to move on, and then everything changes in seconds. Keep your eyes on what happens next because this is a perfect example of how courtroom behavior outside the microphone can matter just as much as what you say in front of the judge.
Thank you. Oh, no. Go get him. Let's get him. Court recalls case, People versus Brandon Hampton. Mr. Hampton, what's wrong with you and why'd you do that on your way out? All right, counsel, here's what I'm going to do. Mr. Hampton, that behavior is not going to be tolerated in my courtroom. At this point, I'm revoking defendant's bond. Defendant is remanded to the Washtenaw County Jail. I'll move his hearing up to next week, November 14, 2024 at 9 a.m. You may take it.
He's in custody, Your Honor.
Oh, he's in, never. He's refusing to come.
Oh, very good. Ask a bunch of people.
That was a dramatic turn. The original issue wasn't even argued. The defendant's conduct became the story. Judges have broad authority to maintain order, and behavior they view as disruptive can have immediate consequences, including bond revocation in appropriate circumstances. Do you think this response was justified, or was it too harsh? Let me know in the comments.
Well, I don't know how good that is. I'm Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Ronald Fleming. Today is the date and time set for a competency review hearing. However, I believe that Mr. Fleming feels that all of these court dates are in the social schedule at the jail. Refusing to come up.
Your Honor, support the receipt of the report from the Center for Forensic Psychiatry finding the defendant incompetent but restorable.
Yes, I am, but I think I need him here to make that.
Yeah, I was going to say, I was hoping we could do that today, but because he's refusing to come out, I just want to make a record that we have received that information, but of course can't proceed forward with it today.
Let me adjourn it out to the 5th. And
Okay.
if you talk to him, Mr. Brown, and he's willing to come up on any Thursday, you can just let us know. We'll try to fit him into our schedule. Won't interfere with his.
Now, if I recall correctly, he refused to come up last time.
He did, and the time before, I think. So it probably isn't going to happen, but I thought I'd make the offer.
This case highlights something many people misunderstand. Being found incompetent but restorable doesn't mean someone is being declared not guilty. It means they're currently unable to properly participate in their defense, but treatment may restore that ability. It's a procedural safeguard designed to protect the fairness of the trial.
Thank you. I appreciate it.
December 5th. Thank you, Your Honor.
December 5th.
All right, thank you.
All right, what are we doing?
So today's the date and time. We've adjourned this a couple times. I did file a motion for discovery. There was one set of medical records that were provided, though not the ones that I actually requested. I'm not wanting to fight over discovery at this stage, Your Honor, and without giving up my right to get those at a later date in circuit court, if it goes there, I think we should just try to get an exam date.
I'm not setting an exam date if discovery is not complete, because then you're going to get to exam. Somebody's going to say, well, I don't have this and I want an adjournment. So we're just going to do it here. What do you need?
So there were 2 hospitalizations that I had advised the government of the people on. There was a Mott hospital in April of 2024. And then there was a IHA hospitalization. Actually, both were in Mott Hospital, 4/24 and 6 of 2024. So that's what I'm looking for.
Yeah, Your Honor.
Yes.
Your Honor, and I want to just make a record some of this. Mr. Margolis already knows I've been sitting in on this case a few times. I'm somewhat advised in communications with Ms. Reiser, but not fully. So I'll make the record as best as I can. Last time I spoke to Mr. Margolis when I stood in on this case, I asked him to be very specific about what records he needs and to communicate that to Ms. Reiser. He may have done so, he may not have. We may have different definitions of what specific is. At this stage, I would not feel comfortable scheduling an exam until I know, especially with the record that was just made by Mr. Margolis, that he has everything that he is entitled to for this case. So I again encourage him to be very specific. By specific, I mean exact date, exact report he's looking for, and to communicate that to Ms. Reiser.
I have no
And
problem.
you could please have an adjournment. Thank you.
Sorry, I have no problem.
I remember this coming up the last time. Did you send those dates to Ms. Reiser?
So I sent an email to her office on October stating Trinity and U of M emergency within the last year on 2 occasions, but I did not send those specific dates.
Okay, so that may be our problem. So are you going to do that now?
Of course.
Okay,
That will solve it. Thank you, Your Honor.
so let's just put this over right before Thanksgiving. November 26, 2024, 9 a.m. Or as your invite indicates, by
Notice how this dispute wasn't about guilt or innocence, it was about discovery. The judge refuses to move the case forward until both sides have the information they're entitled to. That's how courts try to prevent unnecessary delays later. It may seem slow, but it's often faster than restarting the process because evidence wasn't exchanged properly.
continue. Thank
Thank you,
you.
Judge. Always a pleasure.
All right, yep, take care.
Good morning again, Your Honor. Brian Bowling on behalf of Mr. Hamby. State your name for the record.
Joshua Hamby.
Judge, we're asking for an adjournment. Ms.
course
Bush,
you are.
I have our
Go ahead.
closing.
What?
I'm sorry?
No, never mind.
Oh.
Here's Mr.
We're close to a resolution.
What?
We're close to a resolution. We just need a little more time.
You need it?
If I may, Judge. I love your videos on YouTube. I just wanted to tell you, you're doing a wonderful job. I'll be watching it. You're awesome, dude. When I see your face walk out of here, I was like, you serious, right?
Well, thank you, sir.
Yes, sir.
All right. How much time did you need, Gun? Couple weeks?
I think 2 weeks should be sufficient.
All right, very good. Probable cause conference, November 21st, 2024, 9 a.m. Bond will continue. Again, thank you for your kind words.
Appreciate you, Judge.
Thank you, Your Honor.
You kicking butt, Judge.
I'll take that as a legal phrase. All right.